he could have followed in
I
this
think
case.
the thing that makes your case a little quirky, this case, is the friend, the compatriot, who's doing exactly the same thing.
Right.
And no one is suggesting that he couldn't get a pre-enforcement, couldn't bring a pre-enforcement challenge and get a personal injunction in this way. I understand he tried and failed on the merits, but he still was not barred. And it just seems so strange when, in fact, he was able to establish his standing on the basis of Mr. Olivier's conviction and then get into court and try to seek this kind of relief. But you say Mr. Olivier can't because of his own conviction.
Well, I understand, Your Honor, but I think that's a feature of my case for two reasons.
It's not a feature that defeats it?
Well, not at all, Your Honor, because again, heck is personal. It's about who falls within the class of persons in 1983 that can satisfy all the elements of the claim, and if he has the conviction, he can't, even though somebody else can, and that just proves the point that the necessarily implies test is satisfied.
But isn't the element really only there if the kind of claim he's bringing is like a malicious prosecution claim? In other words, the element isn't there if he's saying my claim is not I'm trying to challenge my prior conviction. It's like I was maliciously prosecuted in the past. What I'm saying is this is an unconstitutional statute and should not be applied to me in the future. One could argue the element isn't there in that circumstance if that's the claim he's making.
Well, I think that what this court's precedents say is what we're trying to figure out is what is in the domain of habeas. And the domain is much wider than access to habeas. We know that because of the McDonough case. That person was not even convicted, and that's still within the domain of habeas. And so what the cases tell us is that once there's an extant conviction, we apply the necessarily implies test, thumbs up or thumbs down, and that tells us what is within the domain of habeas. So that's all we're asking in this case is this to apply the same test it has for the past 3 decades, and it's either a thumbs up or thumbs down determination, and we think we satisfied that test. And back to the point about the fellow protester, I think that only suggests why the consequences of this case are not some detrimental consequences. Anybody could bring this facial challenge.
No, but Mr. Olivier can't get post casa any sort of benefit, right? Each person has to bring their own lawsuit to secure the personal injunction.
Well, he couldn't get a injunction that put the city under threat of contempt, but if he got an injunction that declared the ordinance unconstitutional on its face, I suspect he would get a big monetary damages award if the city were to go enforce that unconstitutional ordinance against him in the future. So, I mean, I think that would satisfy it.
Thank you, Counsel.
Thank you.
Justice Thomas? Justice Sotomayor? Justice Gorsuch, anything further?
I just want to make sure I understand how you'd have us read Woolley. It was a younger abstention case. Obviously, Hack says something very different. The two of them are hard to reconcile. What's your best shot in maybe two lines?
How many commas do I get? Abstention case, by its terms, jurisdictional analysis. Heck is elemental, not jurisdictional. Skinner did separate analysis for jurisdiction and for Heck inquiries. And even in its own domain, Woolley has been called the Woolley exception that applies to state interference with daily life activities. And we get other cases, Huffman, Penzl, that treat it differently. And then you get the lower courts that go into this line about coercive versus remedial measures that limits it even more.
Thank you.
Justice Kavanaugh?